31, 31st.
The foundational facts of the case.
My friends, foundational facts are this, my lords, that I'll just place the first issue, the first paragraph in the judgment. If your lordship comes to page 37, annexure 1 of my brief, your lordship takes the second brief first, 1863. A short issue, your lordship probably also has delivered a judgment. The issue that arises for consideration in this writ application is this: whether senior unreserved category candidates can be deemed denied promotion to the higher posts under
Senior reserve.
senior reserved category candidates can be denied promotion to the higher post under unreserved category, ignoring their seniority. Now, my lads, the facts are this. The petitioners in that case, that is the private opposite parties here.
Promotion is seniority come merit or merit come seniority?
Merit cum seniority is there.
Merit come seniority.
Merit cum seniority. Due regard to suitability. ODRS rules, my lords. It is attached, flagged here. ODRS rules are flagged here.
Rule 11. Rule 11.
Annexure 14, page 161. That is Rule 11. Rule 11.
Just reproduced it.
Promotion to the
At page 101.
166. 166.
101 he has reproduced it.
Yes, madam. 101 probably is reproduced. The judgment is reproduced, yes.
Promotion to the cadre of revenue inspector shall be.
Promotion to the cadre of revenue inspector shall be made on the basis of merit and suitability in all
Seniority.
with due regards to seniority from amongst the amines and assistant revenue inspectors of the district who on the first day of January of the year in which the committee meets, provided that the percentage of promotion of amines and ARIs, assistant revenue inspectors, to rank of revenue inspector shall, as really as possible, be proportionate to the total strength of such employees continuing on a regular basis in the district. Now, this is the rule, the genesis of the issue before your lordship, my lords. Now, your lordship may also turn to another rule in the same, my lordship, page 169, rule 22, reservation. Rule 22, that's at page 69, reservation. Notwithstanding anything contained in these rules, 1. Vacancies shall be reserved for direct recruitment, absorption and promotion. 169, page 169, running page 169. On the second rule. We are handing over the rules for your lordship.
Which one Xerox copy? We don't hold the books on a very heavy page till evening. Get the Xerox of that copy. We are requesting the all members to view Xerox copies. First the title, Xerox, then relevant rule Xerox, 2 pages. We can't hold them in pages in our hand.
Well, this is there in the brief itself, page 169.
Yes.
In the second brief, your lordship comes.
Yes, second brief. In the second brief, it has come in.
Page 169. We have annexed the entire rule.
169.
169 in second brief.
With your brief tasking. We take your tasking.
Second brief.
Second brief ta diyo to.
1863.
Which rule you want us to see?
Rule 22.
20.
Reservation.
Reservation. Notwithstanding anything contained in these rules, 1. Vacancy shall be reserved for direct recruitment, absorption, and promotion in favor of candidates belonging to the scheduled castes and scheduled tribes, and shall be filled up as prescribed in the Regulation of Vacancies,
As prescribed in the 1975.
my lords, ORV Act 1975 and rules prescribed thereunder. So, my lords, the roster has been made applicable. Now, my lords, take your lordships to the judgment.
What the learned single judge says, roster is applicable.
Honorable judge proceeds on an analysis that says there is no embargo relying on Sanjeev Roy. Union, page 58. In a recent case, that is Union of India versus Sanjeev Roy, the Supreme Court held, On an analysis of the aforesaid cases, we summarize as follows. Whether a reserved candidate principally proceeds that since there is no embargo under the ODRS rules, the rules that were just being read to your lordships, for giving promotion to reserved candidates into unreserved, my lord, seats. So therefore there is no bar. In doing so, my lords,
Kindly repeat.
the Honorable Single Judge proceeds on the premise that the rules themselves do not make any impose any embargo
Or against?
against reserved candidates to be promoted against unreserved vacancies on merits. Since there is no embargo in the rules, so therefore they can't be stalled.
Yeah, because that's what say.
That is
The rule is,
mallet.
a general merit candidate cannot put his hand into the seats earmarked for
Mallets.
reserved candidate.
Mallets.
Reserved category candidates can compete with the general merit.
On merits.
Yes.
Correct.
On merits.
Correct.
Mallets. So therefore, your lordship, that would beg the analysis, as I would submit to your lordship, that would beg the analysis. The question that has been framed, the issue that has been framed, my lords, by the Honorable Single Judge, I would most, with great humility and utmost, my lords, I'll submit, utmost humility I'll submit, that the issue itself has been wrongly, may not have been correctly framed, my lords. The issue that arises for consideration in this writ application is whether senior reserved category employees can be denied promotion to the higher post under unreserved category, ignoring their seniority. Now this judgment unilaterally proceeds on an analysis that whether they can be denied promotion only because of seniority. There is no assessment and there is no discussion regarding merits. That because your lordship's judgment also, I am aware of your lordship's judgment as recently as this is in Litu Behra case 24636 of 2024. Your lordship delivered the judgment on 3/9/2025. Your lordship's own judgment.
It's a single judge.
Yes, lordship single.
What has been held in this case?
No rate application I will not. I found out if my learned senior kindly permits me to place this judgment, that's besides the point. That's not what I was placing. I was placing something else. You also may kindly turn to paragraph 3.1. Everywhere in the accent, my lord, your lordship will see paragraph 3.1.
Do you have another copy of that?
I copy one copy. I'm sorry, my dear handicap.
Well, I have got the caveat. I am appearing for one of the opportunities. Here your lordship has taken into consideration his seniority.
Kindly allow me to place. Hold your enthusiasm for the time being. Lordship, paragraph 3.1. Let's read this together. Petitioners inter alia. This is how your lordships are proceeded. Petitioners inter alia along with private opposite parties herein, comma, were in favor for the very same recruitment. Filed advertisement number 13 of 2017-18 issued by the Odisha Public Service Commission. Petitioners figured at serial numbers 12 and 13 in the final select list dated 31/10/2018, whereas all the private opposite parties figured below, as reflected in the OPSC notice number so and so dated 31/10/2018 at Annexure 1. It is true that petitioners take their claim for appointment under reserved category since admittedly they belong to scheduled caste. It is obvious. This is where, my lord,
They figured above the private OP.
it is obvious, figured of the private, not the social status, but because competitive merits in the private exam. So therefore, there was a level playing field there. 335, Article 335 of the Constitution, my lord, that balancing factor, which has been emphasized in all the judgments, right from, my lords, Indra Shawni to Virpal Singh, all those balancing factor, my lords. on the basis of financial list, they came to be appointed as lecturers. Now, my lords, in this case, admittedly, the opposite parties were recruited on a special recruitment drive held only for scheduled castes, reserve categories, and that is how they came in. So there was no competition at that level. So there was no level playing field. There was no competition of merits, even at the entry level. So now, my lords, that is where, my lords, the analysis needs to be done in tandem with, my lords, Rule 22. The impact of Rule 22 has neither been examined by the Honorable Single Judge, nor, my lords, your lordships, it has not been argued that way before your lordships. And it was not argued that way before the earlier bench also. That 22, the impact of 22 and the ORV rules has not been placed before your lordships, and that has not been examined. I'll place that.
See, 22.
Well, 22 of the ODRS rules, the rules that we were just placing, Manas, page 169. Rule 22, reservation. Specifically it provides, this has been completely, Manas, glossed over. Notwithstanding anything contained in these rules, vacancy shall be reserved for direct recruitment, absorption, page 169, and promotion in favor of candidates belonging to the scheduled castes and scheduled tribes, and shall be filled up as prescribed in the ORV 75 and rules thereunder. Now, my lords, your lordship may kindly come to the ORV Act. ORV Act, my lords, your lordship may come to section 12, section 11. I'm sorry. Thank you. Section 11 first, my lords. 11A. এটা अच्छी बॉइट दे दें रिपोर्ट करेगी तो लक्ष्य में काइंडली हैव दिस ORV Act 11A where promotion I'm sorry, Mars.
Made on the basis.
Rightly, my friend is suggesting that I start with 10 first. Promotion based on seniority cum fitness. 1. Where promotion is to be made on the basis of seniority subject to fitness, the scheduled caste and scheduled tribe officers shall be promoted to the next higher post or grade against reserved vacancies, provided they possess the minimum qualifications and experience required for such promotion. 2. Number of reserved vacancies.
What one says.
Mallards.
What you have read it one.
10.
10.
What does it say in your understanding?
Only promotion based on seniority.
10 says.
10 says.
Then 11.
Then Mallards 11. Where promotion is to be made on the basis of selection. This is another genre. Of Mallards promotions. Where promotion is to be made on the basis of selection, comma, the procedure for filling up of the reserved vacancy shall be as may be prescribed, and the number of reserved vacancies will be determined on the basis of reserve points shown in the roster maintained under section 5. Under the ODRS rules, the promotion is to be based on selection. That is the basis. Then Manus 12. Selection from different services. Where selection is made from different services, the recruiting or appointing authority shall select scheduled caste and scheduled tribe candidates to the extent of the reserved quota, comma, provided such candidates satisfy the minimum conditions of suitability, qualifications and experience laid down in respect of the post concerned. Then, my lordship may come to Rule 19, Section 19, overriding effect of this Act. Provisions of this Act shall have effect notwithstanding anything to the in any other law or any other rule, order or resolution made by the state government. Now, your lordship knows 16(4)(a), Article 16(4)(a) of the Constitution enabling. So, in order to grant that 82nd amendment, the 77th amendment granted that you could also grant to overcome Shawnee that you could also grant reservation in promotion. That was 16(4)(a), simpliciter. Then that amendment to any other class or post or class or post, that comes in 82nd Amendment of the Constitution, my lords. 82nd Amendment, that gives that is how, my lord, that gives the retrospective seniority, and also, my lord, it widens the field, but it can also create a class and grant, my lords, consequential seniority to the reserved candidates. So all this has to be done, your lordship knows, my lord, and will appreciate that it has to be done by way of an enabling provision, which has to be done and has to be given the teeth and armed by way of a legislation. It can't be done by in a simpliciter manner by law. So therefore, my lords, my submission before your lordship is this, my lords. Now your lordship may.
What is the fault with the judgment? The judgment appears to be consistent with the long line of rulings of the Supreme Court.
My lords,
Unless your opponents dilute our view by their argument, as of now, we are not convinced. The judgment is in accordance with the decisions of the apex court.
my lord, your lordship may kindly see this judgment.
What is the fault line in the judgment?
Fault is, my lords,
Absolutely in accordance with the apex court judgment.
I'll tell you, lordship, what's that. In 2019, 19/1/2019, my lords, the petitioners before your lordship, the appellants before your lordships, there was a regular DPC held and they got promotion. And my lord, that was challenged, which was ultimately set aside. In 2020, there was a DPC. In 19 we got another DPC.
2019 itself.
Another second DPC was also in 2019, where my lord, the juniors came in. And they're in position as on date. Then 2020, there was another DPC. Juniors was further, another set of juniors, they were promoted and they are also in position. 21, 22, another set of juniors were promoted. Now at this stage, after working for 7-8 years, we'll be reverted below our juniors, at least 3 batches juniors who are already in position and were all working. Now that would be one incongruity which will be unfair to us, one. Secondly, my lords, there are 40, for the present moment, my lords, there are 40 vacancies. There's an RTI document taken out by my learned friend. 40 vacancies there are.
When the other side can be accommodated.
Yes. Well, right now, till your lordship decides the issue, without reverting us for the time being, whether we can still continue, and without suffering the impact of the order for the time being, till the issue is decided. Because there is no pleasure in being removed right now just to satisfy the opposite parties. Whether we can withstand, whether we can bypass the impact of the order for the time being, till your lordship decides the issue.
No, but there is no arguable point. As of now, you have not convinced us on any point.
Well, it's your lordship may kindly bear with me. That only the reversion part one, and secondly, it's a parallel bench, coordinate bench of your lordships. I've already stated that another judgment in the same light. In the same light, the ratio has been stated. Please.
Identical matter.
Similar matters. Similar logic, similar reasoning, my lords. Your lordship has also referred to Lalit Nayak's judgment in your lordship's order.
This is before which bench now? It will come before this bench only.
Yes.
It comes before this.
Come before this bench. It should come before this bench.
We will call this matter along with the present matter.
And there's one more matter pending.
That Lalit Kumar Naik case which they have been referring to,
let me
there the judgment was with regard to work out a promotion policy. Here they have considered each and every individual cases. That the SC candidates were never considered for promotion. They were never into the zone of consideration. Forget special drive. That point which they are raising, that is not. The issue was that they were never considered for promotion.
That is-
Valuable rights were taken away and injustice has been meted out to SC category right from 2019 onwards. And every year, what has been challenged.
Lordship's judgment covers the entire gamut of the case, my lord. And it is not a question of evaluation of merit. It is a question of reserving certain things for a general category. But
There is nothing like reserving something for a general category.
That concept itself is not there.
Our judgment would have said.
If you are coming zone of consideration by virtue of your seniority,
They are
then
entitled.
you are entitled to a consideration. Your merit can be evaluated with general category.
We'll call this matter also together. We can decide both the matters together because there is some order now.
Only.
Huh.
But only thing is that because of the pendency of this case, they are not giving us promotion.
No, we'll fix it.
If they are promoted, we don't have any grievance.
Get them on.
That if we are promoted, it's retrospective effect. We have no-
They say we cannot be disturbed
Yes, that's big.
having been appointed for promoted.
If they are, if we are giving retrospective effect of promotion,
They will be disturbed.
Well, option was, well, the learned single just gave them that option. They did not avail it. At that time also, they said, no, we want to argue on merits. Then he said that the consequences will be dire. You take your stand. If you want to rely that we are not to be promoted from retrospective effect, you please give up, tell your stand. They said, no, we want to contest. The same plea which my
I am
learned
relying
friend is
my
taking,
thoughts.
that was earlier raised. So they can't stand. Now they
if they give
go back
us,
upon and say,
My we are now prepared before the honorable single.
So we
But I am relying my lord's
happened and what exchange took place.
may I say,
I am relying my lord's
may I
judgment.
venture to suggest something? But they are telling that if we are not, giving promotion, they have no objection.
Provided their apple carts are not disturbed.
Yes.
That.
So, we are giving retrospective promotion from the date of their, no, otherwise giving seniority.
Even seniority. With one seniority means you are given promotion from that. We are not objecting that. We are only paying.
We should not be repeated.
the graduation list has to be redrawn from the year 2009.
Our reversion is subsequent. Our reversion may not be what in effect too.
And in my lord's judgment, that your lordship, there your lordship has granted the promotion without disturbing their promotion. And your lordship has granted the promotion from the date when they were promoted. That's my, I have given that copy.
With retrospective effect.
Yes,
But not disturbing already those who are.
The apple cart will never disturb by your lordship.
So that is the only grievance before my lord. And I have seen that judgment. I also submit there is no fault with that judgment so far as the merit is concerned. But only one part that in the during pendency of that rate petition, three promotions have been made. As we are promoted earlier, in the subsequent DPs we are not considered for promotion. And admitted fact, our juniors under your category, they were promoted, now they are in a promotional post. And admitted fact, there are 40 vacancies in the rank of revenue inspector.
So what we can suggest?
How many vacancies are there?
After the 2019,
You are not permitting judges to speak at all.
my lords, my lords.
You are in the relay of arguments.
Well.
One, second, third, fourth. There is no coherence at all.
My lord, my lord.
And quality of arguments also is not that high. Quality is not that high. Anyway, suppose what I am suggesting is, because almost identical matter is being argued before the larger bench of the Supreme Court now. Almost identical.
Yes.
So what we are just thinking aloud is, whatever vacancies are now available, let the vacancies be filled up in a normative way without disturbing those who have already been promoted.
Yes,
and we shall fix a date, so
Yes.
that they also are not put to any prejudice.
Yes, ma'am. Yes.
I have a slight objection, my lord. Into this suggestion, my lords, I will only suggest that various writ petitions are pending in the High Court. Around 10 applications have been filed, wherein, my lord, perpetual illegality has been committed year after year. Because as if UR is a reserved category, they have proceeded on that notion and they have never considered and they have wrongly applied the principle of post-specific reservation, which was the moot question before this court following R. Nagraj case. So what has happened now, all these petitioners who belong to SC categories, they have challenged in the subsequent year. Now, if your lordship confines it, that the vacancies will be filled up, then their right also goes away without giving them any opportunity of hearing. They are now, all these writ petitions are sub judice before your lordship in the year 2022, 23, where whatever DPC has taken place, they have relied upon a circular relating to the year 2019. That circular was declared illegal by taking into consideration R.K. Sabarwal's case, Indra Sawhney's case, Saurav Kumar Yadav case, all cases were taken into consideration. They said that meritorious candidates in the SC category have to be considered under a unreserved category. That was the first point which was decided. Then the question comes whether total non-consideration is permissible or not. Now, by your lordship, in this judgment led by this honorable court, they have categorically held that no, it cannot be. So total non-consideration is not the case. So therefore, there is no error apparent on the face of the record. So whatever proposition, what they are submitting, well, your lordship will consider it in this light, that subsequent writ petitions are pending, because if all the posts are filled up, then their rights will be also affected. Taking into consideration that, your lordship may pass whatever.
Your lordship has, your lordship, in your lordship's judgment, has categorically dealt with this problem. To consider candidature as a promotion and grant such promotion with retrospective effect without
From the
monetary.
date, the others were promoted without affecting their apple cart.
Yes.
If we agree with you, then there is a larger question which has remained unconsidered, maybe because the bar did not debate it in the light of Sabarma, YK Sabarma.
That does
So-
arise for consideration in this case, because UR cannot be a category.
It can never be the result. It
cannot be
It is never a category.
Never a category.
If that is the case, then at least the reserve candidates were in the gradation list senior and under the zone of consideration should have been considered. That is the only point. So Nagraj and other things we are not seeing in going into.
Nagraj is from Karnataka.
The constitutional amendment was challenged, it was upheld.
Okay.
But they said that while upheld that
You
you
want to say that they don't know this basic.
I don't know what my learned senior is focused at, but I would definitely differ in his contention. With so far at what he is raising.
Heard that senior advocates, you are on KVH.
Yeah, yeah.
That senior advocates appearing for the appellants
University.
and representing the KVS. Perused the appeal papers. Matter requires a deeper consideration.
And now we decided and covered it.
And therefore, the position held by the appellants herein needs to be protected without interdicting the filling up of 40 available vacancies. In a normative way. First now. In view of the above, first now, next paragraph. Learned advocates appearing for the appellants notified to us an interim order made by a coordinate bench of this court in a pending case in writ appeal number 2395 of 2024, Interim order dated 2011-2025, made in pending writ appeal number 2395 of 2024. First one. We assert that the fact matrix of the said writ appeal nearly matches that of the appeal at our hands. And therefore, protection of the kind granted in the complete writ appeal needs to be extended to the appellant's hearing. Even this aspect also needs to be examined. And therefore, writ appeal number 2395 of 2024 can also be taken up on the day when we are hearing the appeal at hand. Next paragraph. When you were promoted?
19-1, 2019.
19-1-2019. We are told at next one. We are told at the bar.
No, that is wrong.
Sorry.
19-1, 2019.
19-1, 2019.
11-12?
19-1, 2019.
11-12, others were promoted.
We are told at the bar
Respondent. He was promoted on 11-12, 2019.
that the appellants herein were promoted with effect from 19-1-20 2019, and therefore pending adjudication of the appeal, their position has to be protected. There is force in this submission. First, in the above circumstances, any other party, all are on caveat or notice has to go.
No, we have accepted, we are for caveat for some party. My learned senior is also appearing for one of the parties.
And any other parties are unrepresented.
No.
All are represented.
Yes.
No, some have been the state is appearing, other private parties notice has to go. If
the private
ARA किसने option दिया?
In the above circumstances, we make the following order. Issue emergent notice to OP numbers 1 and 2. First one. Letter ASC Mr. Sen accepts notice, Ray accepts notice for the said OPs. OPs are respondent. What is respondent? First one. Notice, issue notice to the private respondents who have not entered KVL. Returnable within 4 weeks. First one. Next paragraph. In the meanwhile, the impugned order judgment is hereby stayed, subject to the condition that such a stay shall not come in the way of the 40 existing vacancies being filled up in a normative way, subject to outcome of the appeal.
Where will be, our cases will be affected.
From 2019, we have to.
2019 we have to be considered with review DPC to be review DPC to be.
We cannot be professors coming into the
We'll fix a short date. We'll dispose of the appeals.
1 month is a long way. Already your lordship sees the date of the judgment and 2 days.
Next one. For this appeal, along with the writ appeal number 2395 of 20.
Your lordship clarifies that there is no bar for holding the review DPC. Yes.
We also, before that, we also make it clear that we are not interdicting any review DPC if
As
the
directed
same
by-
is
as directed by the Honorable Single Judge.
As directed in the impugned judgment, provided that the apple cards of the appellants are not disturbed.
Yes, sir. Great, sir.
For the time being.
Huh?
For the time being.
That's the date.
But at least you have lost it decided.
Other cases were to be
They have
done.
to decide. We can't fix without service of the notice to rest of the people. Now you are also protected by some order. Yes. Up to notice. Service of notice. Therefore, we are not fixing the date. Yes.
Item 7.